Welcome to This Explainer. Today, we're going to unpack exactly how human rights are actually enforced around the globe using some incredibly fascinating source material. We hear the term human rights all the time in these high-minded United Nations declarations. But the reality of how those rights are protected on the ground with actual legal teeth, well, it's a wildly complex story. It's a story of clashing philosophies, historical scars, and vastly different degrees of political willpower. So, let's dive right in with a fundamental question. When human rights are violated, who actually holds states accountable? You might instinctively think of massive global bodies, but the reality of daily, binding enforcement often falls to organizations much, much closer to home. The answer? It lies in regional human rights regimes. And by definition, we aren't looking at one giant, monolithic global system here. No, it's more like a wildly varying spectrum of multilateral frameworks. Depending on where you live on the map, regional protection might mean a powerful court that can forcefully override your government's laws, or it might mean a nascent committee that barely has the power to monitor a situation, let alone enforce a legally binding ruling. Here is our roadmap for today. 1. The human rights spectrum. 2. Europe, the enforcement standard. 3. The Americas, overcoming dictatorships. 4. Africa, balancing rights and duties. 5. Asia and the Arab world. And 6. Do regional regimes work? All right, let's kick things off with Section 1, the Human Rights Spectrum, a world tour of enforcement. The absolute crucial takeaway here is that geography largely dictates enforcement. These regional regimes literally run the gamut, and they are entirely shaped by their own unique historical, cultural, and political contexts. Honestly, there is just no one-size-fits-all approach to justice on the global stage. Different continents have built wildly different mechanisms based purely on what their constituent nations are actually willing to tolerate. Moving right along to Section 2, Europe, the enforcement standard. We'll be looking at the Council of Europe system. Okay, so the absolute crown jewel of the European framework is the European Court of Human Rights. Now, unlike a lot of international bodies, this court exercises what we call mandatory jurisdiction. What does that mean for you? Well, if you're a citizen in a member country and your domestic courts completely fail you, you can literally bypass your own government and take your case straight to Strasbourg. And when this court makes a decision, it creates binding legal obligations. For instance, if they rule that a country's surveillance laws violate human rights, that nation is legally compelled to rewrite its laws. They often even have to pay out monetary damages directly to the petitioner. It's a real game changer. But if we peel back the data a bit, we see that Europe is actually kind of a victim of its own incredible success. Because citizens know this court has actual teeth, they use it a lot. By the end of 2018, they were staring down a massive backlog of nearly 59,850 pending cases. But dig into the numbers, and that backlog is driven largely by just a handful of countries. In fact, nearly 2/3 of those pending cases come from just 4 nations: Romania, Russia, Turkey, and Ukraine. That immense volume usually points to some pretty deep systemic legal shortcomings and political volatility back home, driving folks to seek outside help. To really put the sheer power and volume of Europe's system into perspective, get this. Their court has issued roughly 18,500 judgments since it was founded in 1958. That is highly active, highly utilized international justice that literally alters the domestic legal landscape. All right, let's cross the Atlantic for Section 3. The Americas, overcoming dictatorships, focusing on the Inter-American system. Now, in stark contrast to Europe's tens of thousands of judgments, the Inter-American Court had issued only 397 judgments through November 2019. 397. Let that massive gap sink in for just a second. Now, you might be thinking, wow, is the system just broken? Actually, no. This staggeringly lower volume doesn't mean it's failing at all. It reflects a regime that was historically designed to tackle really severe systemic abuses by military and authoritarian governments. You see, during the post-Cold War era, a lot of South American countries were transitioning out of brutal military juntas. So instead of dealing with everyday civil disputes, the Inter-American system spent decades establishing these really profound, sweeping legal precedents. A perfect example? The right to truth. When those dictatorships fell, a lot of the outgoing regimes passed blanket amnesty laws to save themselves from prosecution.
But the Inter-American Court stepped right in and said, no way. They ruled that transitional governments have an affirmative legal duty to investigate and prosecute those past violations, effectively tearing down those amnesty protections so citizens could finally find out the fate of the disappeared. Pretty powerful stuff.
Next up on our world tour is Section 4, Africa, Balancing Rights and Duties. Let's look at the Banjul Charter. Okay, so there is a really deep philosophical divide between regions here. While Western philosophy focuses super heavily on the absolute rights of the individual, Africa's 1981 Banjul Charter takes a different path. It uniquely balances individual rights with explicit obligations toward the community. It actually outlines defined duties, like preserving and strengthening social and national solidarity. It's a really fascinating attempt to weave different cultural systems of justice and communal responsibility into one single regional framework. However, mechanically speaking, this system faces some pretty significant challenges. Back in the 20th century, newly independent African states were laser-focused on national consolidation, literally building their states from the ground up. Because of that, the regime included what international lawyers call clawback clauses. And frankly, these act as a massive legal loophole. For instance, the charter might explicitly guarantee your freedom of assembly, but then it follows that up with a clause saying that right exists except as restricted by law. So what does that mean? It means if a government decides to just pass a domestic law banning protests, they can legally deprive people of their freedoms while technically staying perfectly compliant with the regional charter. As you can imagine, that significantly weakens any actual enforceable protections. Moving right along to Section 5, Asia and the Arab world, nascent human rights regimes. Over in Asia, the primary sub-regional body, the ASEAN Commission, operates under an almost absolutist view of state sovereignty. In fact, their guiding documents explicitly prioritize non-interference in the internal affairs of member states. Now, when you put state interests and preferences above universal human rights standards, well, it renders the organization fundamentally toothless. Think about it. If a member state is committing severe violations, this foundational rule of non-interference legally forbids the surrounding states from stepping in or aggressively investigating. Their hands are essentially tied.
And the situation with the Arab League system is incredibly challenging too. Sure, they adopted a human rights charter back in 2004, but it completely lacks any complaint or individual petition procedures. And to give you a real sense of where this regional effort currently stands, the source material points out that the Arab League's official human rights portal is literally a broken link on the internet. Yeah. It just goes to show how nascent, symbolic, and under-resourced these mechanisms are right now, especially when you compare them to the heavy hitters in Europe.
So this brings us to our final section, number 6. Do regional regimes work? Assessing multilateral impact. After touring these wildly different systems, do they actually work? Well, the short answer is yes, but in very, very different ways depending on where you are. Even the weaker, nascent systems offer some absolutely vital benefits. For one, they provide culturally credible scrutiny. This is huge, right? Because it directly undercuts that common excuse authoritarian leaders use that human rights are just some alien Western standard being forcefully imposed on them from the outside. Plus, these regimes offer a valuable second set of eyes. Over time, they actually help socialize hesitant states to the whole idea that, hey, your internal practices are legitimately subject to outside review. But here's the absolute most crucial analytical takeaway from all this source material. It boils down to this profound quote: strong regional human rights regimes are more an effect than a cause of good human rights performance. Let me explain what that means. Authoritative enforcement, the kind we see in Europe, only exists because those member states already respect human rights enough to willingly let an international court overrule them. A strong regime doesn't just magically create a pristine human rights record out of thin air. Actually, it's the other way around. Strong domestic human rights records are what allow a powerful regional regime to exist in the first place. Which leaves us with one final, absolutely vital question to ponder as we look toward the future of global justice. As regions like Africa, Asia, and the Middle East continue to develop both economically and politically, will their nascent human rights regimes eventually evolve? Will they one day wield the binding, authoritative power of their European counterparts? Or will state sovereignty always remain the ultimate shield against outside accountability? It's a massive, ongoing question for the future of international law. Thank you so much for joining me for this explainer. Keep asking those tough questions and keep looking at the data.